Madam Chair, Vice Chair, and members of the committee, I'm Christina Delmont Small. I'm a member of the Board of Education of Howard County, and I'm speaking as an individual. Like many of you, I ran for office to strengthen the voice of our citizens. I wanted to improve the accountability, oversight, and transparency of our school system. In the recent election, 3 incumbents lost. Citizens were under the impression they had a voice, only to find out that even with a board consolidating their positions, the superintendent has no requirement to comply with directives of the local board. The current law is the barrier to the board executing its fiduciary duty. It prevents local control of education. Currently, there are no consequences if a superintendent does not follow directives from a local board. In fact, a superintendent could sue a school board for such efforts. What happens is to a superintendent, the local board becomes a minor hurdle, an obstacle to be overcome, not an employer. The local board is at the mercy of the superintendent, and the result is a board unable to carry out its duties under Maryland law. A healthy system of checks and balances and oversight creates a framework for true collaboration. The board needs to be changed, the law needs to be changed to facilitate true checks and balances. What if you were able to hire but not fire your staff? What recourse would you have if they didn't do what you needed and wanted them to do? For example, the Howard County Public School System is nearly a $1 billion per year school system. What board of a $1 billion organization is unable to remove their CEO? In Howard County, over 50% of our county's budget funds our school system and accounts for 72% of the school's budget. Yet, there is no elected body truly responsible for $1 billion of taxpayer money. Our local boards cannot effectively represent our citizens or manage and safeguard the assets of our school system. Will taxpayers continue to be willing to fund local school systems if there's no oversight on how billions of dollars are spent? Local boards can meet with parents and teachers, but if problems arise, there's nothing we can really do to help them. If we need more teachers in the classroom, for example, and we're unable to get basic funding information such as approved budget data versus actual budget data to analyze where our money is actually being spent, how can we fiscally be responsible and make those decisions? Decisions that directly impact our students, and even if we do, the superintendent may not execute the budget priorities of the board without penalty. The voices of parents are vital to a successful school system. HB1603 will ensure that voice is strong and is heard. If you believe parents, citizens, taxpayers, and your constituents should have input into the decisions of their school system through their local board of education, decisions that directly impact the health, welfare, education, and future of their children, please support HB 1603. This legislation is necessary to ensure a process that is good for our citizens and the running of our school systems. A favorable report will establish accountability that will enable local boards to work with superintendents to ensure our school systems operate and allocate resources so our youngest citizens have the best opportunity to learn. Thank you.
All right, thank you. Any questions for this panel? Delegate Lutke. Oh, I'm sorry. I apologize. Were you testifying as well? I thought I saw check marks.
Oh, I'm all by myself.
Okay, go ahead.
Oh, you want me to go ahead? All right. My name is Cindy Vaillancourt. I'm the chairman of the board of Howard County Public Schools. Our board voted 5-2 to support this legislation. The 2 dissenting members cited concerns about due process and checks and balances in the current draft as their concerns. In response to their concerns, we have not had an opportunity to meet as a body, so I will be responding to going forward as an individual. The overall concept that the local elected boards of education must have the legal ability to effectively provide oversight for nearly $12 billion of taxpayer money in the state of Maryland, not to mention the education of Maryland's children, by having the authority to manage and, if necessary, terminate its own employee, the local superintendent. It's critical to local control over education, but more importantly, it's critical to representational government and the ability of the taxpayers and citizens of Maryland to have a meaningful voice in the use of their tax dollars. However, there have been some legitimate concerns about the current bill raised, which I believe can be addressed with 3 amendments, and I've provided all of you with a draft of 3 different parts. First, that the state superintendent may continue to remove a local superintendent for cause. That's what's currently provided in the education article, and now that authority would be granted to the local board. But I would also offer that the additional amendment that the superintendent would have the right to a hearing in person or by counsel before the body proposing the removal. and the right of appeal to the State Board of Education. This is more protection than currently offered, and it sets a specific appeal process and is consistent with how all disputes are currently adjudicated through the Maryland Public Schools. The State Board is the body to which all appeals are forwarded. Second, the local boards should have the ability to include mutually agreed upon termination clauses in the negotiated contract. In the event a board and a superintendent find they can no longer work together effectively, either ought to be able to initiate an amicable dissolution of the contract. Currently, a local board cannot even buy out the contract of a superintendent who has ceased being ineffective or responsive, or has ceased being effective or responsive, but may not rise to the illegal, immoral, incompetent, or neglectful deficiencies that would lead to termination for cause. Concerns about instability and the supposed vicissitudes of partisan politics, in the words of the 1900s, that upon the election of each new Board of Education, each new board may choose to exercise the buyout provision willy-nilly. I propose an amendment requiring the agreement of the local funding authority for the exercise of the termination clause. As a practical matter, boards of education's budgets don't include a line item for superintendent termination, so they would have to go to their local funding authority for approval. And I'd also like to suggest, and it's in the amendments, that maybe the initial contract could be 4 years and should continue to be 4 years, but subsequent renewals should be 1 year.
All right, thank you very much. We have several questions, starting with Delegate Lukey.
Thank you, Madam Chair. Thank you both for coming, and thank you for your service on your Board of Education. 2 questions. One, the Maryland Association of Boards of Education submitted testimony opposed to the bill. Have you all had a chance to talk to them?
Actually, we talked to Mr. Willems, who's their liaison with you all. The report that the Howard County Board was given by our legislative liaison indicated that the concerns that were raised in the legislative committee at MABE were that there were due process issues and that the proposed law might be unconstitutional. That was surprising to Mr. Willems, so I'm not really sure what part of that conversation occurred. As I understand it, the opposition has been to these, what could be minor tweaks in the law, but I can't speak for them because I wasn't there.
Okay, and then a question, let me play devil's advocate for a second. A couple of years ago in 2015, the superintendent of Hillsborough County Public Schools in Florida was fired summarily by her board. She was nationally recognized and respected, and it was a bit of a mini scandal at the time. I don't know if you recall. And so what's to prevent this process from being infected by politics, right? Because things can become that way.
They can. And I think that maintaining the provisions that a termination for cause would still be required to have illegality, immorality, corruption, willful neglect of duty, and an appeal process to the State Board of Education, which the current superintendent statute doesn't have. The question of whether boards would exercise buyout provisions that had already been mutually agreed to as a secondary option, I think would be, and have those, the exercise of that clause be required to be reviewed by the local governing authority, the county council or the county executive or whatever the individual county has, would provide a buffer for that kind of thing. I don't see boards willy-nilly firing superintendents, but I do see superintendents not feeling an allegiance to a board that has no authority over them.
Right. Thank you very much.
And I can answer Delegate Howard's earlier question about how this bill would affect Prince George's, and it doesn't. It specifically excludes Prince George's because you all do, as you know, have an unusual situation that grew out of the Iris Metz case in 2002.
All right, Delegate Howard has a question?
Yes, thank you very much for that clarification. But just another correction is, I don't think Iris Metz was fired, so you might check that.
No, what happened? Yeah. I can't. The nutshell is that there was a contract provision, they tried to exercise it, and it was determined that they couldn't include that kind of a contract provision, which is when most of the state learned that there was even a provision that the local boards couldn't hire their own superintendents, even with a mutually agreed to
I
contract
do
provision.
remember that. Thank you. That's what I wanted.
Delegate Turner?
Yeah, just a couple of questions real quick. You mentioned in your testimony that you have an amendment which will establish the due process by having, if the locals were to decide to terminate the contract, there is an appeal process. The appeal process would go to the state superintendent once a hearing has been held. Is that correct?
Once the hearing's been held, in my amendment, or you feel free to amend it further, if it's the state superintendent who has moved to have the local superintendent removed, then the hearing would be in front of her and the appeal would be to the State Board of Education.
Okay.
If the local board requested the removal, then the hearing would be in front of them and then it would be appealed to the State Board of Education, which is consistent with how all appeals are currently handled. Right now, the State Board of Education does not have that appeal authority.
Right. Currently, there is no appeal process to the state board, right?
Not at all.
But this amendment would allow, so that if we fired locally, you still would have an appeal process, therefore making sure due process was intact.
Absolutely, more so than is currently available when a single individual is in charge.
The other question I wanted to ask you, Bill Small said there's an issue about exercising the direction of the board. Can you give me some examples of when you have made a decision and that decision was not followed at the board level?
Well,
Well, either one.
We're trying to figure which one. Budget?
well, we recently learned that the superintendent's position is that regardless of the budget priorities we might set, after the budget is approved, then she would exercise her administrative authority to make changes to it that she deems fit. But specifically, the one that is, we're involved in some litigation, so some of this is not necessarily widely known, but since it's a public record, it would be. The board voted to reimburse Mrs. Croupiers, who is the person who had to sue the Howard County Public School System to get an MPIA filled that was ultimately determined by the ombudsman for the state of Maryland with your assistance was illegally kept from her. And there were many thousands of dollars, $9,300, something like that, that she paid in sanctions to the Board of Education as a result of that litigation. And we voted to reimburse her for it because it was very clearly determined that it had been an egregious abuse of our discretion not to fill the MPIAs. And the superintendent has determined that we do not have the authority to make that decision, and she refuses to do it, and has in fact filed a complaint against us with the State Department of Education to have them declare that we do not have that authority.
And the challenge that we're having is we just went through the first part of our budget session, and we had asked the superintendent to provide for us from fiscal year 13 to the present the actual budget data versus the approved budget data, so that we can look at trends and make sure how is funding actually, where is our funding really going in Howard County? And she basically refused, and staff has not provided the information to us. So the challenge that we have as a board is that we need data and information from the professional staff in order to make decisions that are going to concentrate our dollars in the classroom, but we're unable to do that because we don't know where the dollars are.
And we can't force it.
Okay.
All right, thank you.
Thank you.
If there's no other questions, thank you both very much. Thank you.